You're on
And
mute.
of course, I realize I'm muted. Yeah, thank you. So, thank you, first of all, Tamika, for having me. I really appreciate the chance to provide this presentation, everybody. My name is Chris Arroyo. I'm the manager of the LA office of the State Council on Developmental Disabilities. You can think of me, if you know Tamika and her role very well, you can think of me as Tamika in LA. But maybe with not quite as much style. So, anyway, so we're here to talk about special education evaluation. So, the first thing I'm going to do is share my screen so that we can all take a peek at this information. Um, so, I'm going to rearrange my screen a little bit, and I apologize for that. But I want to make sure that I can pull everything up easily on screen here. Okay, so the first thing that we're going to talk about is the first thing I'd like to talk about are um, the handouts that we are going to have available for you. So what we're going to do is have available, and this is going to be dropped into the chat, and I'll do it momentarily. But what we're going to do is drop all these files into the chat so you can download them. And inevitably, what's going to happen is people are going to come in a few minutes and they're not going to be able to get a copy of it. So you're going to hear me repeatedly say to people that we will email these out, and at the end of the presentation, I will be dropping a copy of all of these files into the chat. So that won't be an issue. Okay, so the first thing I want to go over with you is our IEP strategy guide. So this guide is going to be available, and again, we'll be putting this in the chat, and it's more or less a very, very brief summary of the IEP strategy presentation that we've given over the last 2 weeks. We did part 1 2 weeks ago, we did part 2 last week, and today we're doing special education evaluations. We're also going to drop into the chat and post and send to you via email as well. Enough is Enough, which is our anti-bullying handbook. In here are a number of strategies that people can use to work with schools and districts, as well as IEP teams to create strategies to reduce or eliminate bullying. Lastly, is we have our booklet on developmental milestones, which we are also, of course, going to be providing to all of you. And we're going to talk about this book quite a bit today because you'll see it's going to be important to understand developmental milestones in order to understand evaluations. Now we've got a number of other handouts here that we will cover throughout the presentation. So the first thing that I want to get started with is what this presentation is about. So this presentation is all about evaluations. For those of you who attended the training that I had performed about 2 weeks ago, you may recall that we spent a substantial amount of time on the bell curve, which, to remind you all, looks like this. And we spent quite a bit of time on that. And I had said at the time that I could easily do a 2-hour, even an 8-hour training on this stuff. And here we are, and we're going to be doing about a 2.5 hour training on evaluation. So let's get into it. The first thing is we're going to talk, and some of this may be repetitive. If you've seen this in the previous parts, I apologize, but I'd like to give a complete presentation so that everybody can understand all the content. Inevitably, the questions that you ask me today in this training they're going to require you to take certain actions. And these are more or less the complete common list of options available to families. This by no means is a totally complete list. It is not. There are some other options that aren't on this list, but these are the most common. These are the things that we see most frequently. The other stuff are things that I might recommend to people literally maybe once or twice a year of the dozens and dozens of question and answer phone calls I've done with people. So let's get into it. So schmoozing. Schmoozing is the first option, and schmoozing is essentially getting things done with a wink and a handshake. Schmoozing is the idea that you get things done informally, and generally they require you to have at least some degree of trust, if not a large degree of trust, for the people that you're working with. So if you've got that trust if you can do it informally, then schmoozing is a great option to get things done. Now, the thing is sometimes people don't have that option. Okay, maybe you don't feel like you can do it informally. It's high stakes stuff. It's really important, and so you might find yourself wanting to write a letter to create some evidence, to create a paper trail. If you're going to do that, or you feel the need to do that, schmoozing is not the best option because, again, it's informal. The minute you take it from a wink and a handshake and take it to something that requires you to create documentation, you've removed the informality of it. And the other party will be offended. Oh, wow, I thought we were going to do this informally, and now they're turning into a whole big formal thing. Oh, my gosh, I can't. No, 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 no. No, we can't deal with this. And that's basically going to be the outcome. So you got to have trust, and you've got to know that you can keep it on an informal level. Second thing are IEP meetings. IEP meetings are fantastic options in order to get a new service or change an existing service. Okay, IEP meetings are perfect for that. Getting a new service, changing a service. However, IEP meetings are terrible for dealing with a problem because there's something in the IEP, a service in the IEP, and it's not being provided to your child or to you. So if there's a service written into the IEP and it's not being provided, in a situation like that, the best option may be a state compliance complaint. Now, a state compliance complaint is essentially a complaint that you make to the California Department of Education, also known as CDE, California Department of Education. And it's basically you informing them that the school district is not following the law. It's an allegation from you that the district is not following the law as written. Well, the law says that the school must implement the IEP as written. So, a state compliance complaint is perfect for that kind of an issue. Okay. Now, Tamika, some of you may notice that Tamika has dropped into the chat a flyer. And basically, we're going to be providing a training on January 13th about state compliance complaints and how to write them. So who do you file it with? How can you do it? How do you get it done? Everything. So that's all right there in the chat for you. And so you'll be able to pull that information and join us for that presentation. So let's get back to the main presentation. So state compliance complaints are great for allegations that the district is not following the law, including if you request an evaluation or an independent educational evaluation and the district fails to respond. Law requires them to respond. Pardon me. Excuse me. So with state compliance complaints, you can go back as far as 1 year. Excuse me. So you can go back as far as 1 year with a state compliance complaint. With due process, you can go as far back as 2 years. Due process is basically appealing the decisions of the IEP team because you disagree with them. Another reason why you might want to do due process is if you want to make the allegation that the district has failed to educate your child, that your child has failed to benefit in some way from their education, that they failed to provide a free, appropriate public education, an education that's free of charge at public expense and is appropriate to your child, meaning it's geared to your child's unique needs. Okay, so that's critical. With due process, we generally recommend that people do get a special education attorney to represent them. Usually this sends chills up people's spines when I say this, because a lot of people think, oh my gosh, it's really expensive to get a lawyer. I can't afford it. That's really not fair. I should be able to get a lawyer too. Well, fortunately, the law agrees with you. And essentially, if you win, let's say you hire a special ed attorney You win your case against the school district. The school district must reimburse you the cost of your attorney's fees. So that's a huge tool in the parent toolbox, because ultimately what that means is, even if you've got no money at all, you should be able to find a special ed attorney to represent you for free. And if you win your case, the district will reimburse you, essentially paying your lawyer their fees. So it's really a great option for people, and it is reachable by everybody, whether they've got a large amount of money in their bank account or no money in their bank account. So it evens the playing field. The other thing about it is that it requires you to prepare your case well, because here's the thing. A lot of families report to us that they feel like special ed attorneys seem to fall into multiple different categories, of course. But some of the things that people have noticed and said to us is that it seems like special ed attorneys are either interested in buying their new car, their new house, their new boat, their new whatever, or they believe that special education is a civil right, and so this is a civil rights fight to make sure that children get the education that's appropriate to them, per the law. So what we find is that some attorneys are very willing to work with families at low cost or for free, and there are some who absolutely are not willing, and that's fine. That's their purview. Those who will do it for low cost or free, um, they will represent you if they're confident they're going to win your case. If they're not sure that they can win, if the evidence isn't present, there's not enough written evidence, it's just your word against theirs, that kind of stuff, it will stop an attorney from representing you who might otherwise be willing. Because if they don't think they're going to win, they know they're not going to get their fees back from the district. So it's really important that you prepare your case to the best level possible, so that you appear to the lawyer as a very low maintenance client. This is very easy. This case is cut and dried. I got lots of documentation. So we're going to get into those strategies a little bit later on. We got heavily into them last week and a bit into them 2 weeks ago. So that's due process. It's the way to resolve disagreements about the IEP, or if you need to make an allegation that your child isn't benefiting from their education, essentially that the school has failed to do its job. Okay, OCR complaints. OCR stands for Office of Civil Rights, and the Office of Civil Rights exists within well, as far as I know, every federal department. So, we have a federal Department of Transportation. They have an Office of Civil Rights. We have an Office of Civil Rights within the Department of Education, the federal department. Now, when we say CDE, we refer to California Department of Education. Sometimes people will say DOE for the Federal Department of Education, DOE. So bottom line is and these offices exist because of our country's history of segregation and discrimination. That's simple. So an OCR's department, an office of civil, I shouldn't say department, should I? An office of civil rights should conduct investigations for any allegations of discrimination. The most common situation where we find ourselves recommending this option to people is when a school is doing their field trip, like the big field trip for the year, and they tell you that your child has to stay at home because they don't have enough staffing, they don't have enough intervention, whatever it is that they need. And so with this allegation that you make, all you do is simply write a letter to the Office of Civil Rights. If you go to Google and you do a search for Federal Department of Education, Office of Civil Rights, I believe it's the first link. And then they include all the information, email address, everything, where you can send the complaint and the format. But again, basically you write a letter. Generally speaking, what we've heard from families is that the soonest OCR has been able to respond to a complaint like this has been 2 weeks. That was unusual. Typically we hear about 1 month. And families tell us it can take as long as a year for OCR to work on an issue. So the thing is, what we found is people tend to be really happy when they've made these complaints for, like the example that I gave you, because ultimately what it does is it requires the school district not only to change its policies and its procedures, but it may also require administrators and staff to go through training. And that tends to be one of the ways in which we see changes made. So understand, if you make an OCR complaint, it's not necessarily going to ensure that your child can go on the field trip. If the field trip is next week and you make the complaint today, it's really probably going to be unlikely that OCR can respond so quickly. However, that said, sometimes we've heard from people that OCR made it, someone made a complaint quite a while in advance of a field trip, and OCR actually made an informal call, got everything worked up and fixed, and the parent was willing to release the complaint. We've seen situations like that as well, where the parent wasn't willing to release the complaint, didn't want it resolved informally because they wanted to see lasting changes made at the district. Your choice. If you're fortunate enough to have that option, then you choose what's appropriate to you. So again, one more time, state compliance complaints, you can go as far back as 1 year. Due process, you can go as far back as 2 years. Okay. OCR complaints, as far as I know, there's no limitation. However, I would suspect that anything over a couple of months, maybe 6 months, might be too stale for them to investigate. That is purely my supposition. That is my guess. So, if you got an issue that's a year old and you want to give it a shot, give it a shot. There's no reason not to. Okay, options, other options. So public participation. What I mean by public participation is essentially you providing input or testimony to a Department of Education, a school board, to a Board of Education, or to the Community Advisory Committee, the CAC, of your local SELPA. And I know that's a lot of initials that I've just thrown at you at one time. So SELPA is Special Education Local Planning Area. Special Education Local Planning Area. And a SELPA CAC, Community Advisory Committee, or Board of Education, both of them must hold meetings in accordance with the Brown Act. As a result, any person can offer public input or testimony on any agenda item and on things that are not on the agenda. So that's a great opportunity for families to provide their input and basically tell the district what's needed to fix things or to improve them. So one of the things that I need to point out about this is the fact that, let's see, how's the best way I can put it, is the idea that, if you go and you talk to the school board or to the CAC and you say, hey, look, me and the district, we've had some rough patches lately. We're not getting along. We don't agree on a lot of these issues, et cetera, et cetera. You need to fix things. The board or the CAC is going to shrug their shoulders. They're really not going to know what to do. If you say, hey, look, I had a disagreement in my IEP, the first thing they're going to think of is, oh, well, you can go to due process. That's something that exists to resolve problems in that. So my point in talking about this is the idea that you need to understand their perspective. The perspective of the board and the CAC is to make sure that overall this system is functioning. The system is working. The gears are working together well. They're not separated so people fall between the cracks. They're not grinding people up in the gears. They just want to make sure the machine is functioning. So one of the things that you need to do is put your issue or your problem in terms of the system itself is not functioning. Because again, if you say, well, I've got a complaint about this, that, and the other, they're probably going to look to offer to you as a way of helping you one of these options that we've already talked about. Oh, well, you can do a complaint, you can do a due process, you can do this, you can do that. Okay, great. So how do you put it in terms that they understand? Well, let's say today the theme is evaluations. So let's use evaluations as a theme. if you, let's say you got evaluations and they didn't describe your child, they described someone completely different. You felt like it really didn't capture who your child is. One of the things you can do is provide testimony and let people know that there needs to be some procedure or process where a supervisor of an evaluator reviews the evaluation, right? Because if you say, hey, look, I disagreed with the district about the evaluation, they're going to say, well, you can do an independent educational evaluation. That's an option available to you. Or you can work with the school to see if they're willing to reevaluate the student. Okay. But that doesn't necessarily solve the problem at hand if the quality of the evaluation is the thing that you're pointing out. So what you can do is basically in public participation, say exactly that. Hey, look, the system itself isn't working because many evaluations of low quality are getting out there. It's not just me that's impacted by this, it's other families as well. So I would recommend that you create a policy or a procedure that requires the supervisor of the evaluator to at least review and sign off on all evaluations. I think that may save the district some money in independent educational evaluations, and it will help people feel a little more at ease about the evaluation that they're getting. Thank you very much, right? Usually you're gonna have 2 minutes to testify. So that's public participation. Redefining the issue that you have in terms of a failure of the system. Okay, because once again, if you can bring it back to one of these issues that we've already talked about, if an IEP is a possible solution, no one's going to listen. If it's a state compliance complaint, nobody's going to care. Okay, now I'm facetiously saying no one's going to listen, no one's going to care. Of course people listen, of course people care, but you know what I mean. They're going to be listening to the issue you're presenting to them, and they're going to be looking for an existing process that they can hang on and tell you, well, you can do that. And again, your job is to essentially say it's a problem with the system overall, and it requires action on your part. Okay, then we have letters of understanding. With a letter of understanding, this is essentially creating a paper trail. Okay, it's creating evidence. And there are a number of reasons strategically why, which we'll talk about in a bit. But I want to talk about what is a letter of understanding and how to do it briefly. So the first thing is, with a letter of understanding, the first thing that you've got to do is make sure that the folks who that whoever receives the letter of understanding is not really your audience. Okay, that's the first thing. So you're going to send a letter of understanding typically to the principal of your school, and maybe send copies to the assistant principal and the teacher. Okay, and the thing is in the letter, you want to make sure that you write the letter in a way so that people understand the situation at hand. And what do I mean by that? Okay, first of all, your real audience is the judge that's going to hear your case up to 2 years from now. Your real audience is going to be the SELPA CAC or the Board of Education. The real audience is going to almost always be somebody other than who you're sending the letter to. So that's the first thing. Why? Why is that important? Because here's what families tell us, and sometimes we've seen this in letters that families have provided us, which is they say, look, you told me a month ago that in 2 weeks you would do this, that, and the other. And you didn't do this, that, and the other, and you don't keep your word, and you always lie to me, and blah, 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 blah. People get angry and they tend to write it that way. Rather than doing that, because here's what's going to happen. The judge that's going to hear your due process a year from now, you're not even sure that it's needed. A judge is going to hear that, is going to read that letter a year from now, and they're going to read it and go, oh my God, this parent sounds so unreasonable. They're so angry. Oh my gosh, I have to protect those fine people at the school from this parent. And that's the way they're going to approach the issue. Okay, typically, not always, of course, there's always exceptions, but that's generally how people are going to read it. Now, if on the other hand, you write the letter as, hey, you told me a month ago that you were going to take care of this thing in 2 weeks. And unfortunately, an additional 2 weeks have passed and I haven't heard anything. Is everything okay? Are you all right? Have you gone on vacation or are you sick? I really hope you're okay. Fingers crossed. But right now I'm looking to resolve this issue. So please let me know what's going on. If anything in this letter is incorrect, please inform me within a reasonable period of time. Magic phrase, you close every letter. Every letter should be closed with that phrase. I'll talk about that in a minute. So bottom line is when you change your tone like that, now the judge that reads your case a year from now, and they read that letter, they're going to say, oh my gosh, wow, this person's pretty understanding and it sounds like something weird is going on at the school. I think I'm going to have to need to get to the bottom of this. Boom. So you just took somebody who had you written the letter in one style, might have said, oh boy, I got to protect the school from this parent. Now is instead saying, hey, there's something weird going on and I need to peel back the layers of this onion to figure out what it is. Very, very cool. Okay. You want to use the magic phrase, what I call the magic phrase. If anything in this letter is incorrect, please inform me with a reasonable amount of time. And the reason why is because if they don't respond, it makes it look like everything in your letter is factually correct. And one of the most common comments we get from families is that no one responds to their letters. So let's let that lack of a response work in your favor. Okay. Now, sometimes people write these letters and they use this phrase, and then the school says in, like, let's say in a due process hearing, or even in a state compliance complaint when they're responding in writing to the California Department of Education's investigation, they might say something along the lines of well, unfortunately, everything in the letter, it wasn't correct. We just didn't think it was correct. And then the school will say, well, then why didn't you tell mom and dad about that? Because they asked you to. I'll say, well, we just didn't know. It was a miscommunication. We didn't get it. And what typically ends up happening is the judge or the Department of Education, whoever it is, ends up holding them responsible for failing to inform the family. So there's kind of an obligation, there's an implication that there's an obligation on their part to correct your understanding of where things are at. Pretty simple. But using that idea, that simple idea strategically, what you can do then is memorialize everything that needs to be put in writing. You can create evidence, and it won't ever require you to testify. It won't. All you do is just put a stack of letters in front of a judge or the investigator, whoever it is. Now, one of the things you need to do is make sure that you are sending it in a way where you can prove that they received the letter. Okay, so you can send it registered mail, which is half the price of certified mail and serves more or less a similar function, which is to provide the sender with evidence that the letter was delivered. So when you send a letter in the Postal Service, you can attach a little pink card to it and you fill it out with, who you're sending the letter to and all that stuff. You put in your address. And what happens is when the letter's delivered to the school, someone is going to be required to sign that card. The card gets removed from the letter and it gets mailed to you. That card is now evidence that the person who signed the card on that day basically received the letter. That's your evidence. So it's really important. Another thing you can do is send it via fax, but only if there's a miniaturized copy of the first page of your fax. Okay, so usually people are familiar with a confirmation page that produces the date, the time, the number of pages that were faxed, the phone number it was faxed to, all that kind of stuff. And sometimes that's it. That's all they have. That's no good. You got to have a confirmation page with a miniaturized copy of the first page of your fax. And you put it in the fax machine as if you put it in an envelope. And the reason why you do this is, again, to prove you sent the letter. So when you address the letter, when you type it up, when you write it up, write it in a way like you're going to put it in an envelope. And basically at that point, once you send it and you get that confirmation, it's the school's responsibility to get it to the right person. Now, sometimes schools will say, well, look, oops, sorry, we never got the letter. Well, if you have proof that they received it and they claim they never got it, indeed, maybe they never got it. If you sent it to the principal and the school received it, it was signed by the school secretary, maybe it was lost between the secretary and the principal. Who knows? But it's totally reasonable. I mean, mail gets lost. Stuff happens. Here's the thing. Once you prove they received it and you sent it to an official agent of the district, so generally an official agent of the district is the principal. They're high enough on the chain of command where they have some authority. And so if you send it to them and it gets lost and they claim they never got it, but you have the evidence that they did, what you should do is basically say, you know what? I am more than happy to give you another copy of that letter, because you're always going to keep copies for your records. More than happy to give you a copy of that letter. But please understand, that letter, I asked for an IEP meeting. I asked for something. And the legal timelines say that that must happen within 30 days of my request. So even though it was lost, I can't be responsible once it goes through your front door. I can't go from office to office and deliver letters. I'm not allowed to do that. But once it gets to your door, it's your responsibility. So I'm happy to give you another copy, but please understand that the timeline started when I originally sent the letter. Then what do? You immediately go home, write a letter and say, dear principal, whoever, thank you so much for letting me know you never got the letter that I sent you 3 weeks ago. Attached is a copy of the registration card with the signature. I'm sorry you didn't get it. Here's another copy of the letter. Please understand that the timelines have begun from 3 weeks ago when I originally sent the letter. Thank you so much. Please let me know if you need anything else. And if anything in this letter is incorrect, please inform me in a reasonable amount of time. Boom. Now, there are a couple, another third option is copy with a time date stamp. So you can deliver it to the district. They can stamp it with the date and the name of the district, make a copy and give it to you. If they do that, fine, totally works, A-okay. Thing is this, people ask, well, what about email? Email, you can't prove they got it. Naturally, immediately people say, but whoa, whoa, whoa. If they respond to my email, well, then indeed, my email will be below that, and then I have proof. Well, yeah, but then here's the problem. Judges generally don't want to read, I don't want to say even generally, but special ed attorneys tell us that about half the judges they see who hear their cases, about half will reject email conversations, because when you print them, they're either huge or there's a lot of data or there's a lot of stuff to flip through because everybody's replying back and forth, and so you get all those old emails underneath and you got to flip to find the new stuff. It just seems like people may not want to deal with it. So my recommendation is use email if email is natural. However, if you're concerned about this, as I would be, if email is natural, use email, but then write a letter of understanding periodically. How often? Oh, I don't know. Once a week? Once every 2 weeks? I don't know. It depends on how active things are in your situation. But generally what I have found is that you should not wait very long. If you wait too long, it grows stale and your letter can look like something other than what it is. It could look like retaliation. It could look like, you're trying to memorialize and put something in writing that's really old now. It just doesn't make a lot of sense sometimes. So this forces you to strike while the iron is hot. So my recommendation is to always write letters of understanding in a pretty timely period. The other thing is people say, when I ask to be informed by the school, you're telling me to do it with a reasonable period of time. What's a reasonable period of time? Why can't I just say 3 days or 5 days or 10 days? The reason why is because each judge decides differently what the standard is. Some judges will say, well, a reasonable time period, there's no emergency here or anything. So, 2 weeks is fine. There are other judges who say, oh my gosh, this seems pretty important. This seems like a big deal. Yeah, I think we're gonna have to, yeah, I think a reasonable timeline here would have been 3 days, 5 days, right? So whatever the timeline is that the judge selects, I don't like putting the number of days down. I have friends who work at schools who've told me that they get told, and please respond within 2 days. And it makes them angry because they're like, look, I have no obligation to respond within a time period. I got other responsibilities. I got an IEP at 3 o'clock. I got this, that, and the other. So bottom line is they're under no legal obligation to respond within a certain time period. The standard by which judges seem to apply this thing seems to be, I don't want to say all over the place, but seems to vary pretty widely. And so with those two factors, to me, it's just not worth putting in a time. I think it just makes more sense just to say, in a reasonable period of time. Lastly, again, the point of a letter of understanding is you want to memorialize things that have occurred. You want to prove that they happened, whether it's a conversation, whether it's an incident, whether it's something that occurred, whatever it is. You just want to put those things in writing so that you can prove that they happened later. Okay, let's move on. So, a couple things to remember. IEPs, getting services, it's a deficit-driven process. In order to get a service, you've got to prove and demonstrate that there are things your child cannot do. And we know that that is awful. We know that it just sucks because you're talking about your child in negative terms. You're always fighting to make sure that people understand that your child has capabilities and can do stuff. And yet here in the IEP, it almost feels like you're taking a step backwards. We understand that. But please understand that if you put on your proud parent hat and nothing else, and only talk about how proud you are of your child and how great they are and how wonderful everything's been, that's cool. But understand it's probably going to result in few to no services. So again, everything's a deficit-driven process. The other thing is that the school has an obligation to provide an adequate education. What is adequate? Adequate is that your child meets their IEP goals. That's what adequate is. So bottom line is that schools can say best all day long. We want to provide the best education, the best. We want to provide children, the best preparation for college, university, post-secondary education, whatever. Thing is, you can never say the word best, especially when you're talking about services. But in general, you just shouldn't use the word best with the school. Use the word adequate instead. So instead of saying this is the best therapy, whatever it is, this is the best therapy. Instead of that, say, this is the most adequate therapy for my child. Okay? Because the minute you say, this therapy is the best, you've removed it from the table. School can then say, we don't have an obligation for the best. So, sorry, we're not going to do that. What is the most adequate intervention for this student? We believe, and then they'll tell you. So bottom line is use the word adequate. Now, regional center does have the obligation to provide optimal. So the standards are different. And please keep that in mind when you're at each of those meetings, the IPP or the IEP meeting. Okay, rights law. Laws of adverse assumptions. The laws of adverse assumptions basically say a couple of things. So rights law, let me get a little deeper. So rights law is a special ed law firm for families. They put out a number of publications with a lot of strategic information and legal information in them. Their books tend to fall in the two categories of legal and strategic. And people report to us that they are incredibly happy with the information in those books. Our office has actually sponsored Rights Law to come out and do a presentation, and it was incredibly well received. And people got a free publication with that presentation. So it really worked out well. One of the concepts they put forth is the idea that there are adverse assumptions. There are bad things that we have to assume are going to happen. So what are those things? The first thing is you must request due process to resolve your disagreements with the school. So right away, we're talking about you need to go to the level of due process to resolve a problem that you've got with the district. Secondly, you're going to be the one that requests the hearing, which means you're going to have the burden of proof. You're going to have to prove your case at this level, and the district is only going to have to defend their case at this level, at this lower level. If you have the burden of proof and you have to prove your case at this level, it means you're going to have a harder time proving what you need to prove. Okay. and because you've got that burden of proof. Secondly, you have to assume that all school staff will testify against you and remember the opposite facts as yours. They'll remember the opposite facts from you. And so the reason why is because, first of all, many, the vast majority of the families that we've spoken to and special ed attorneys tell us that this is the common experience of many people. Okay. Now, right away, families say, oh, so that means they're liars. Look, I'm not saying they're liars. I don't know their intent. Okay. I don't. But we can assume that generally speaking, they will remember the opposite as you. Okay. And so with that, if they're going to remember the opposite of you, it's going to be your word against theirs. Okay. And that's a tough situation to resolve. The second thing is you have to, or the fourth thing is you have to assume that the hearing officer is biased against families. What does that mean? That's not my opinion. It's a fact. Judges, for example, judges are instructed that if it's your word against the district's, they're instructed to go with the word of the district unless they have reason to doubt the school district's credibility. That's a huge hurdle to get over, because if you have a psychologist who testifies about something with your child and they do as well, the judge is going to go with the school district psychologist. So they are biased against families. And then lastly, assume you cannot testify. We see in all the movies, the lawyer tells their client, you cannot get on the stand. We cannot put you on the stand. It's such a risk. Da, 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 da. Well, that's true of due process as well. And so what is the solution to this? If you can't testify, you've got this huge burden of proof. It's your word against theirs. The judge is biased against you. What can you do? Letters of understanding. That's why letters of understanding is such a huge part of the parent toolbox. Okay, so again, these laws are based on the common experience of many people, and so the strategies that we have developed are directly to address these issues. Okay, we've talked about the IEP structure before. Evaluations are conducted because the school officially doesn't know your child, not in an objective way. And the evaluations identify the things that your child can do particularly well and poorly. And so the plops, the present levels of performance, it'll always give you chuckle if you refer to them as plops. But plops describe evaluations more or less in common language and break it up by subject matter and performance issues like gross and fine motor skills, academics, that sort of stuff. The goals are based on the present levels of performance. A goal should be developed for each thing that your child cannot do that is identified in the plops. The accommodations and modifications are usually based upon the evaluations. The services are usually based upon the goals. If you have a lot of speech goals, it would be my expectation that I would see at least some speech services. And then the placement is sort of the grouping of these three things, of the goals, the accommodations, and the services. So, and each one more or less leads to the next as I've described it. Okay, so what we're going to do, we've talked about this in the previous trainings. I'm not going to get too much into it, but the bottom line is the idea here is that a lot of families seem to approach the IEP process backwards. A lot of parents sit there, don't say anything during the meeting, and then at the end of the meeting, they talk about all the services that the child needs. And the problem is that when each part of the IEP is based on some previous part, if you don't participate at those portions or those sections, then when you make your request for services, it's going to be just floating in the air. It's not going to have any support from down below. So the way I think of this is like a pyramid where the evaluations, the plops, the goals, the accommodations, modifications are all the lower levels of the pyramid. And at the very top of the pyramid are the services along with the placement. And so if you're looking for a particular set of services and you don't participate in the earlier sections of the meeting, then essentially you're not creating the foundation for why that service is necessary. It just won't make sense. So the thing is families, of course, do not approach the process backwards. It's just that you in the back of your head are constantly evaluating your child. You're constantly setting up goals. You're constantly figuring out where your kid is with different kinds of things. You're constantly working with them because nobody knows your child better than you. Nobody, no matter what initials are after their names. They may know psychology better than you. They may know speech therapy better than you, but they don't know your child better than you. And so the thing is, you may want to do a parent report so you can explain to the IEP team what are your concerns. Okay, that way later on, if there's a disagreement a year from now, they cannot say, or they can say that they didn't know that that was a problem for you. But the fact is, if you provided them with a parent report, you've got evidence that you can demonstrate they knew. And if they failed to incorporate that in the design of the IEP, that was their responsibility. Okay, now evals, let's get to the core. So evals, it's really important to understand them before the IEP. And the biggest reason is because you want to prep your questions for the team in advance as much as possible. Okay. So in last week in IEP part 2, we talked about using questions as a strategic tool to both gather information and try and change the mind of the person you're asking the questions to. So they're a tremendously powerful tool. You have the right to have evaluations done every year. So the school has the obligation to do evaluations at least once every 3 years. You have the right to ask for them every year. And a lot of parents tell us that they do ask for evals every single year because they prefer to have an objective test, an evaluation, determine the progress that their child has made over the previous year, instead of, or in addition to, teacher observation, testing data, informal observations, that sort of stuff. So, and why? Because an evaluation is a formal tool. It's a way to get specific kind of information, including the progress that somebody has made. Now, it can be done more than once a year if the school and you are in agreement. So if you got an evaluation done 6 months ago and you want to do it again, the school has to agree. And if you're both in agreement, then fine. Likewise, if the school wants to do an evaluation after 6 months since the last one, they need your permission to do it. You can say no. Okay. Generally speaking, we find that it's a bad idea not to allow the school to evaluate your child if they feel there's a need. Many special ed attorneys have reported to us that it can be difficult to prevent the school from evaluating a child. And part of the reason why is because it's perceived as the parent providing a barrier to the school being able to do its job. Because if doing an evaluation is the foundation for everything else that comes out of the IEP meeting, and the parent doesn't allow that, the parent is not allowing the school to do what's needed to provide a free, appropriate public education. That's sort of the perspective. So generally, it's not a great idea to say no, but there are some strategies that you can do and follow up to that, which we'll talk about. Additionally, always put your request in writing. So if you want to have an evaluation done, just put it in writing, send it in one of the ways to prove that they received it, okay? Again, they must do it every 3 years. There are a lot of legal requirements, a lot of legal requirements. Now, one of the things that I'm going to do is put in the chat, let's see, sorry, is I'm going to eventually put in the chat this. So this document that you're looking at, and I realize the print is small. We're not going to go over it in super detail right now. However, what this document is it is all of the legal requirements of evaluations conducted by LEAs. So that's another set of initials you can learn. LEAs, Local Educational Agency. So LEA is the legal term for schools, school districts, charter schools, that sort of stuff. And the reason why LEA, Local Educational Agency, is used is because some charter schools are their own school districts. Some school districts use charter schools as a contracted agency. So, because you can, end up going, getting into great deal of detail about, well, this applies to charter schools, but not districts, or this applies to districts, and then making the different, too much. So we just say LEA, that covers everybody. Okay, and we will drop these documents in the chat. I'm just not going to do it right now because ultimately I'm going to have to stop the presentation for about 3 minutes. So I want to stop that, but I will put it in the chat later on. Okay, so again, this document, you can see, occurs at least every 3 years, occurs before a change in eligibility, has parental consent, etc. Again, we're going to go over this stuff a little later on. So many legal requirements. I believe there's 18 on that sheet. Okay, now there are a couple different kinds of evaluations. Evaluations can be diagnostic or for the purpose of eligibility. So to discover a disability and that disability impacts the student in the classroom. That's the eligibility mantra, that there's a disability and the disability does impact the student in the classroom. That's one kind of evaluation, okay? Those kinds of evals not only are to discover a diagnosis, but also to discover the things that a student cannot do very well. So, so more or less, that's going to be all about, you know, what can a student do? Do they meet the criteria for eligibility? That sort of thing. Then there are evaluations on progress. They're looking at particular things. So diagnostics and eligibility looks at capabilities. It looks generally at what is someone's capacity to do something. With progress, progress is more about what's their performance? How did they do? Because think of it this way. A student could have the capacity, the ability to be a straight A student. But if they don't apply themselves, if we're going to ignore learning issues, we're going to ignore disabilities in this thing I'm talking about right now. So if they have the capacity to be a straight A student, to do really well, but then they don't apply themselves, they watch a lot of TV, maybe they play a lot of video games, they don't do their homework, maybe they cut class, all that kind of stuff, their performance is going to indicate that they're not doing well. Their performance is going to show poor. So that kind of information is very valuable, because if we know if someone can do the work, but the work isn't getting done, there's something in there that's stopping that from happening. So then it gives us some ideas of what to problem solve and look for. We're going to get into that in some detail in a minute. But the evals should inform decisions about the services and specifically include the frequency, the duration, the quantity, the method, and the type. If a school district says in the IEP that they're going to provide 180 minutes every month of a service, is that okay? It could be, but did the evaluation say that? The evaluation recommended 180 minutes over a month. Are they really talking in sufficient detail about the frequency, quantity, or duration? Maybe not. I mean, if they say 180 minutes a month and those 180 minutes are done on the last, 3 or 4 days of the month, and then the student gets nothing else, is that okay? For some students, it may be. For most, generally not. So this is an issue that you need to keep in mind. Placement, the results of the evaluation should tell us what kind of classroom, what kind of facilities, equipment, staff are necessary to instruct a student. That all should be there. Okay. The evaluation should inform the team about other treatments, about treatment methodologies, about ways to instruct, about diagnosis, and about severity, about the depth, the impact of that diagnosis or that condition. Okay. All right, we're going to get to the bell curve now, and then we're going to get into some more detail about these different details and the requirements behind the IEP. So first thing we're going to talk about in this bell curve, and follow along with my cursor, is the shape. It's called a bell curve because it looks kind of like a bell. This shape describes a lot of stuff really well, and it describes a lot of stuff really poorly, really poorly. So, for example, for height, this describes height of people really well. right? The average height for a man, last I checked, was 5'9". The average height for a woman was 5'6". So what that means, what makes something perfectly average is the most number of people have it, more or less. So on average, the largest number of people are 5'9" for men and 5'6" for women. There are some people, some fewer people, who are a bit taller than average, who are taller than average. What's that difference? Well, it's the difference from here to here, right? If this is the height we're talking about. And so uh, there are fewer people who are much taller than 5'9". And there are even fewer people who are much taller than 5'9". And there are some even fewer people who are much taller than 5'9". Basketball players. These are people who are over 6 feet tall, maybe even 7 feet tall. And of course, there are fewer people when you go farther out than when you're closer to the middle here in average. Someone just sent me in chat a message. It's sent to everybody, indicating that the district refused to evaluate the child for the last 3 years. Yeah, we're going to talk about what you can do in situations like that, because that's a violation of the law. Okay. Likewise, some fewer people are much shorter than 5'9". I should say we're talking about men in this situation. So there are fewer men who are shorter than 5'9", right? And then there's much fewer people who are much shorter than 5'9". And then there are some few people who may have a diagnosis like dwarfism, who are known as little people, who are particularly short. Okay? And so this describes that pretty well. It describes other things poorly. Someone's asking if I'm going to share on the screen, and I am sharing on the screen. So if you can't see it on the screen, you may want to quit and restart. I'm going to do the same thing. I'm going to stop sharing, and then I will restart the share. So I've stopped sharing, and now I'm going to restart the share, and hopefully that won't lead to a problem for anybody. Okay. So again, huge difference here. Here you've got basketball players, and here you've got little people, right? When we're talking about height, and the largest number of people are going to be the people who are of average height. Okay. Now, the thing is this describes some things really badly. Okay. It doesn't describe traffic, at least in LA, really well. So traffic, at 4 in the morning, traffic may be pretty low. At 5 in the morning, we get a spike. It goes up, and then it goes up even more around 8 o'clock, 9 o'clock. It stays pretty high, stays high throughout the entire day. And then it drops maybe a little bit around 2 to 3 o'clock, maybe just a little bit. And then it pops back up again. At 5 o'clock, rush hour seems to be worse than ever. And it stays high until it drops maybe a little bit in the early evening around 8 o'clock, 9 o'clock. And then again, it spikes back up until around 11 o'clock, 1 in the morning. And then it finally drops off. So this shape does not describe traffic really, at least traffic in LA, really well. Just doesn't. Now, here's the thing. Scientists, evaluators, all design their evaluations such that they essentially have an outcome like this. When they give their test to a large number of people, they've made it so that some of the questions are really hard to answer, and people won't answer. People can't answer it. They're really hard questions. Only a few people get them right. Likewise, they try and design them so that there are a few questions that are relatively easy for most people to answer. Okay? And so what happens is they get this shape. Now, whenever they do the testing and they learn that this shape doesn't hold, that no longer do the results look like this, well, what they end up doing is they end up essentially playing around with the test and change the questions so that it looks like this shape. Okay, so there's that. There's this shape. Okay, now in chat, someone put down, my son falls in below average and deficient, and they're still refusing they still refuse to give the appropriate services. That's when you're going to have to look at things like due process. Okay, But remember, the point of these strategies is to either get success in the IEP meeting or prepare your case for due process so that you can win later. So keep that in mind. That's pretty important. Okay, so again, the bell curve. The way they report the results can be in different manners, okay, different styles. So down here at the bottom, we can see percentile scores, okay? These are percentile scores. Percentile scores, perfectly average, is 50%. Normally, we think of 50% as failing. Bad grade, 50%, no good. Well, the reality is with percentile scores, 50% is perfectly average. Okay, now if your child got a score of 25th percentile, right? Then what they did was they did better than 25% of the students who took that test, and they did worse than 75% of the students who took that test. How did I do that? 100 minus 25, or 100 minus the percentile score. So if someone got 16th percentile, it means that they did better than 16% of the students that took the test, and they did worse than 84% of the students who took the test. So there you go. Okay. The person in the chat indicates that they don't let the person participate at all. They only give 5 minutes to talk in a meeting that's almost 2 hours long, and they're blocking this mom with Zoom. Yeah, so they're blocking your right to participate as a parent, which is illegal. Parent participation is one of the fundamental foundations of special education. And it sounds like you may have a good case. You may want to consult with a special ed attorney to see if they believe you have a good chance in due process. And just based on these facts, if it sounds like you do, but again, it depends on whether or not you have sufficient evidence. Okay, I'm gonna have to start ignoring some of the questions in the chat or the comments in the chat now and just stick to the material. So if you have questions, please feel free to put them in the chat, but I'm gonna have to pick and choose which ones I can respond to for the benefit of everybody. Okay, so moving on. So percentile, that's percentile scores, okay? I don't like percentile scores very much because they lack sensitivity down here below the first percentile, okay? They lack sensitivity, and I'll explain why in a moment. Another way schools can explain the results of their evaluations is through standard scores. Standard scores are just a different way to explain the test results, but perfectly average in a standard score is 100. Now, normally we think, oh, 100, straight A, awesome, wonderful. Okay, but that's not the case. With the standard score, 100 is average, perfectly average. 100 as a percent, 100 standard score is equal to 50th percentile. Okay, they're exactly the same. That's why the line is down here. Okay, so the subtest scores are based on, oh, excuse me. One other thing about the standard scores, every 15 points is a new category. So 100 minus 15 is 85, a new category. That's what this solid line signifies. 85 minus 15, 70, new category. 70 minus 15, 55, new category. 55 minus 15, 40, new category. You get the idea. Now, students in special ed may have results anywhere from 35 to 70, or even greater, 35 to 125. The thing is this, is there is a big difference between a student who has a standard score of 35 versus a student who has a standard score of, say, 60. 35 plus 15 is what? 35, 45, 50. So from 35 to 60, you're jumping a little bit more than even one category. And so the difference between those two kids is very different. However, if those results were reported as percentile scores, both of those students would have their results reported as being in the first percentile. So that's what I mean when it lacks sensitivity. It lacks a lot of sensitivity. Okay, that's why I really don't like percentile scores very much. And again, percentile scores are just a way that the school describes the results. You can see, the reason why I've included this graph is so that way you can see where someone falls on the graph. Because look, where my cursor is right now, If a student falls at this point on the graph, the bottom line is whether that number is 75th percentile, 110, or 12, it doesn't matter. What we know is that student is performing in the average range, slightly above average, but they're still in the average range. Okay, likewise, if a student's in the 25th percentile or they have a standard score of 90, their test result is here. They're still in the normal range. Excuse me, still in the average range. Oh, that's a horrible slip. So they're still in the average range, slightly below average, but slightly. Not enough to even kick it out to a new category. Okay, so that's what I mean. These numbers that are used can be interchangeable in some ways. Okay, because they tell you where the student's performance is or ability is on this curve. Okay, and that's what we're looking for. Now remember what we said in our IEP strategy part 1. If someone has results around here between 70 and 85, my expectation is that they either get something extra in the classroom, something supplemental, or maybe they'll get about a half an hour of a service. Okay. Likewise, if their test results are down here, I would expect that they get about an hour to 90 minutes worth of a service, certainly at least a half an hour. And if their test results are further out, like somewhere 60 or below, 55 or below, I would certainly expect 2 hours a week of a service, no doubt. Okay, so, and again, and this is played out through multiple things. For example, with intelligence testing, there are a lot of subtests within intelligence testing. A student could have a few of those subtests really well and perform above average in those areas, and they could be below average or significantly below average for other areas. And so in that kind of a situation, what do? Well, we write a goal for the things that the student is below average in, and then we look at the depth of the impact of that thing and the intervention that's needed to correct it. And then we decide how much. But again, if I see something in here, I'm kind of thinking a half an hour, maybe an hour at the most. If there's 1 or 2 issues that are heavily impacted. If generally speaking, most of the scores of an area like speech are over here, then I would expect at least something supplemental in the classroom and a half an hour of speech therapy. Okay. And again, we have subtest scores. You can look, subtest scores, perfectly average. What is it? It's 10, right? Obviously, right on that average line, right in the middle. 10, and in this case, subtest score is a new category every 3. 10 minus 3, 7. Minus 3, 4. Minus 3, 1. Does it lose its sensitivity down there? Yeah, but these are subtest scores. I may not need a precise score for an issue that's a subtest. I may have a good idea of just knowing, look, whether it's a 4, a 5, a 6, I have an idea it's somewhere around here. That's fine. It's good enough for me. Okay, same with a 1. But that first percentile, there's still very big differences for many kids who get labeled in that first percentile. So that's a big deal. All right, that's essentially the bell curve. Okay, let's move on. In Spanish, here's another way to translate those scores. Remember, 100 equals 10 equals 50th percentile. It's all right there, okay? Right, to convert the scores. Okay, so one thing I want to mention, this thing. So in looking at your child's evaluations, what you may find is patterns. And some of those patterns can be hard to discover. Okay. So here's something that you may want to do. You may want to print this page. Once this is put in the chat, you can download the document, or you can even make your own like this. Okay. And if you do, I would recommend topping this out at 115 and then have another category here of 55, 1, 1, because that way you can have scores, you can graph out lower scores over here. Okay. Because if your student's in special education or your child's in special education, they may have some deficits below this point on the graph. And what you can do is put similar things on the same line. So for example, you can take an intelligence test and all those subtests, and you can put them here on the line, the same line. So you just put a little dot. Let's say the result is 76. Okay, well then you can find where you think 76 will be. So if we're at 70 to 85, right here is about 8 points. So 76 probably right around here, give or take. So you put a little dot here, and then you put the name of the subtest, matrix reasoning, whatever, hand-eye coordination, whatever it is. And you put it in there. And then you put them all over there for the intelligence test. Then my favorite trick is to take performance testing and put that on the next line. So like the Woodcock-Johnson, that's a very famous performance test. It tells you on what grade level a student is performing. Well, the great thing is they report those in standard scores typically. So you can take the standard score and chart it over here. How great would it be to see a test of ability, like intelligence, with a test of performance, like the Woodcock-Johnson? Because now, if there's a big differential between your child's ability and what they're actually performing at, then we know that there's something interfering with your child's learning. Something, whatever it is. And there's an intervention that needs to be provided to close this gap. Okay. Now, likewise, there's still good information. Let's say all the intelligence information shows that your child is performing in this area, down here between 70 and 85. And then all the performance information says your child is performing up here between 100 and 115. Okay, that's weird, right? Because basically what they're saying is your child's capabilities are here, but their performance is here. That's weird. Someone's exceeding their capabilities? To me, that introduces doubt into the validity of the standard that they're using, this intelligence test, the thing to measure capacity, ability. So that's why I use the terms ability and performance. Okay. So charting that out can give you some really interesting patterns here. What I find speech is incredibly informative by charting it out, because that's where you're going to see things like if your child is a strong auditory learner, visual learner with other kinds of testing, occupational therapy, fine motor, gross motor, you can see where your child's deficits are and relative strengths compared to everything else. Okay. So we're going to work through an example, okay? With this example, the child's full-scale IQ score was 101, okay? So what we would do is on that chart, we would put 101, we'd put a little dot right here for the full-scale score, okay, right there. And then verbal comprehension is 124. Verbal comprehension is more or less a measure of receptive language. So the verbal comprehension, this student, if I speak to them, they're going to get it. 124, huge strength, not even relative strength to this child. This is a strength period. They're doing better than most kids. 124, so what? That would probably be around here, give or take. So verbal receptive language, huge area of strength for this student. 88 for perceptual reasoning. What's perceptual reasoning? It's organization and reasoning with visually presented nonverbal materials. So sometimes the kind of things that we think of with these kinds of testing is we see all those shapes. They'll give you like 4 shapes in a row and say which shape is not the one that belongs, which one doesn't belong, that kind of stuff. So 88 perceptual reasoning. This is an area of relative weakness for this student, right? Their average overall IQ score is 100. Perceptual reasoning is 88, much less than 124. So that 88 would be charted right about here. And then working memory, short-term memory, 110. Area of strength. This kid is going to come across quick, man. They're going to hear what you say. They're going to process it really fast. or excuse me, they're not going to process it fast. They're going to remember what you say, and they're going to be able to spit it back at you. 110. So where does 110 go? What, about here, give or take? Then we look at processing speed, 75. This is an area of relative weakness for the student, 75. So when we go back to the previous slide and we graph it out, 75 would fall somewhere around here. Now, what can we say about this student? What do we know? The student has an average IQ score. If we looked at the bell curve, this student's results are going to look like they're perfectly average right over here. But it doesn't tell the tale. It's not complete to just look at that single score. We know the student can receive verbal instructions and understand them really well. They're going to remember them pretty well. But it's going to take them quite some time to process that information. Also, when they look at written materials, it's also an area of relative weakness. So what do I know about the student? I know that in the accommodations, I would want to see that information that's presented visually is paired with auditory instruction. I'll say that again. Information that's presented verbally is going to be tough for this student to understand. So I want to make sure in the accommodations, they get the information paired auditorily, that it's given verbally. Why? Because this student's they're going to be able to absorb it. They've got a good short-term memory. They're going to keep that info in their head. But their processing speed is an area of weakness. So I want to make sure not only is that information provided auditorily or provided verbally to that student, but I also want to make sure that they're given extra time to respond and that the teacher slows down the rate of instruction. So many of us know people, or we are people, where someone talks to you and you ever go like this. Now look at my picture if you're staring at the presentation, and you go like this. Okay, yeah, now I know what you mean. That's processing speed. If you're going like this for a second or two and people are waiting for you to go, okay, yeah, I'm tuned back in again, you may have delays in your processing speed. Nothing wrong with it. It's just the way we're hardwired. Fine, so be it. Who cares? But the bottom line is we need that extra time. And a student whose score comes down to 75, which is below average, right? Remember our categories of here. Below average, 75 falls what? Exactly right here. That's below average. So we've learned a lot of things, but just by looking at 4 test scores with this student, just 4 scores. Actually 5, I lied, because of the full testing score. Okay. Now, one of the things to keep in mind is when sometimes these evaluations have a full scale measurement, right? It's just the average of everything. It's not necessarily a mathematical average, but it's an average, more or less. I mean, if verbal is 124, working is 110, perceptual reasoning 88, 75, it kind of makes sense to me that 101 is the person's full scale score. It's like a measure to give me a quick snapshot of where that student's at, but it doesn't obviously tell the whole story. Okay, so keep that in mind, because if decisions if the IEP team is making decisions based on whether one score falls right here, that's not necessarily appropriate. Okay, it's not necessarily appropriate for the reasons that we've just discussed, right? Like these areas of weaknesses. Okay, example number 2. This student. Oh, by the way, this testing score, this is a real student, a student with autism. Okay. Try and think about what diagnosis you might think the next student has. This student has a full scale IQ score of 58. So looking here, 58, that's one category lower, right? 170 minus 15, remember minus 15 is 55. So this student has a full scale IQ of 58. So they're right on the cusp of a even lower category. Their verbal comprehension is a 70, strong area of strength. This is a major area of strength for this student. 58 down here, but their verbal comprehension is up here. at 70, right where my cursor is. Then their perceptual reasoning, right? The same stuff that we saw before, perceptual reasoning, organization, and visual material. What happens with that? In this student, it's a 46. It's an area of relative weakness for this student. The working memory for this student is 50. Again, an area of weakness. Their short-term memory. Their processing speed is 44. So what do we know about this student? We know that they can understand verbally. Okay, not great. I mean, it is, let's see. It is below average, 70. It's right on the cusp of deficient and below average. Sorry, I'm in Spanish. Deficient and below average. But it is an area of strength. If I talk to this student, this is probably one of the things that they're going to do well, is understand what I'm saying. They may not understand everything. That's what the 70 signifies. But for this student, their ability to listen is particularly decent, particularly good. Perceptual reasoning, that visual stuff, really throws this student off, really throws them off. Working memory, not so hot, not an area of strength. Their processing speed is even slower than their working memory. So what does that tell me? It tells me this student needs extra time, needs repetition, because that short-term memory is not very high. It's actually quite low. And so because their working memory, their short-term memory isn't very high, they constantly need to be reminded of the thing that we're talking about. Visual information throws this person for a loop, right? They may have some visual processing disorder. They may, whatever it is, the circuitry in their brain, looking at things visually, not so great. So I'm going to want to make sure everything, or maybe not everything, but most stuff, the critical stuff, is presented verbally. The student is given plenty of time to think about it, and it's repeated over and over again, right? But repeated with pauses. Because again, if we don't pause it, all the student's just going to hear is blah, 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 because they're not getting enough time to process that information, that split second. Now, some people need a split second to just go, oh, right, I got you. I know exactly what you're talking about. And other people go, you said this, and you said, got it. That's a slower processing speed. Okay. Some of you spoken with me personally see me do that, because that's what I'm doing. I'm processing it. Okay. Now, this is an actual student as well. This is a student with Down syndrome. Okay. So you guys can see how charting that out on this graph, there we go, lets us see the results visually. I wish I could do it for you. Maybe I need to look at the whiteboard function in Zoom. But you can see how if you put these here, those things pop out, right? I don't need the graph anymore to do it. I've done enough of these where I can look at this and hold this stuff in my head simultaneously and go, okay, right, we got to make sure there's verbal presented information with the visual stuff. Okay, and then we got to give this kid extra time, you know. All right, and with practice, you'll be able to do the same. Now, the other thing is you can look at tests of ability over time. So you can look at the you can look at the current evaluation, put it on this line. Look at the one for the same subject area and put it on this line that was done 3 years ago. And you want to look at the one that was done 3 years before that, fine, put it on this line. And then you can see the progress that your child has made over time. Same thing with performance. You can put performance, the most recent performance evaluation on line 1, the one before that on line 2, the one before that on line 3, et cetera, et cetera. What you'll find is you'll see patterns. Maybe your child's performance is improving and getting closer to their ability. Maybe your child's performance is slipping and the gap is growing between your child and typical kids. And so this can be really informative to tell you about that stuff and those trends over time. Okay, now a couple of things. Let's get into some of the legal stuff and the requirements and get a little bit more into strategy. So first thing is evaluations, the timelines. When you ask for an evaluation, again, in writing, in a way that you can prove they received it, the district must send you an assessment plan within 15 calendar days. So 2 weeks and a day. whether school's in session, whether 2 weeks in a day, whether there's lots of weekends, holidays, generally speaking, that stuff doesn't matter, although it does in some way. I'll talk about that in a minute. So they got to send you an assessment plan. Now, understand at the beginning of the pandemic, there was an executive order that was issued that said, we're waiving timelines for assessment plans. We're waiving the timelines for evaluations. Well, those waivers have since expired and not been renewed. So all the stuff I'm going to talk about, all the timelines that I talk about right now are in action. This is the law as it's written, and there's no suspension to this law as a result of the pandemic. So this is the way things are at. If your school is telling you something different, then I would have to say that they don't understand the law. Okay. So getting in, so must be in a language you understand unless it's not feasible. Okay. So they have to give you the assessment plan. And if you don't speak, if English is not your first language, then they need to give you the assessment plan in a language that makes sense for you. Okay. So if Spanish is your primary language, etc. What unless not feasible means is if you speak a language that very few other people speak. Okay, like if you speak an indigenous language or a language of a country where there are just very few immigrants here, then it's just not feasible. They don't have to translate it. Okay, but generally speaking, if you speak what we call one of the threshold languages, they need to. Okay, what's a threshold language? A language where a bunch of people talk about it, or a language where a bunch of people use it. Okay. You have 15 calendar days to respond to the assessment plan. Okay. So, generally speaking, you have 15 calendar days to respond. Okay. The district can make it longer. So, like if they know you're in the hospital, if they know you need extra time for something that's beyond your control, they could say, you know what, don't worry, take your time, respond in 20 days. Okay. Respond in a month. They can extend that deadline. Okay. But your assumption always should be your deadline's 15 calendar days. That's it. Okay. All right. Once you respond to the assessment plan, you can then sign it. If you don't respond within 15 calendar days, the school assumes your answer is no. So that's why if you get mail from the district, one of the things that you should do is always open your mail immediately and try and respond as quickly as you can. Don't respond on day 14, where then somebody could say, oops, we got on day 17 and you only had 15 days, blah, blah. Try and avoid all that stuff. Just respond within the first 5 days. Okay, don't wait on this stuff. Okay, from the day the school gets your consent, it starts a new timeline. So again, day 0 to 15, day 0 is you send a letter saying, my child needs an evaluation. I'm requesting an evaluation in the area of speech, occupational therapy, and language, whatever, academics. Okay. And they have 15 days to get that plan to you. You have 15 days to get it back to them. And if you don't, it kills the process. It's over. You've said no by your inaction. Okay. Through your inaction, you said no. You'll have to start all over again. Send another request for an assessment plan. They'll send it to you. You can do it. Okay. You're now the squeaky wheel. You're getting noticed because you've sent in the same request because you didn't respond the first time. Try and avoid that. Okay. Be a good customer. Okay. Yes, I know they work for you, but try and be a good customer, right? Always get more bees with honey than you do with vinegar. Okay. From the day the school gets your consent, they have to do the evaluation and hold the IEP meeting within 60 days. Okay. They got to do the evaluation and hold the meeting within 60 days. You have to make your child available for evaluation. Okay. Can't hide them. Can't keep them at home for those 2 months. You do that, they can't do the evaluation. They've got grounds to say we couldn't do it because the student wasn't available. Okay. Now, here's one thing that I was dancing around a little bit earlier is vacations more than 5 calendar days are not counted. So if the summer vacation, if the holidays around this time of year kick in and students are going to be out for more than 5 days. That is not part of the 60-day countdown. Okay, that 60-day timeline of that's how long they have to do the IEP and so on, that does not count if there's a vacation of more than 5 calendar days. Okay. Summer will definitely delay the process. If you want to have an evaluation done and conducted before the end of the school year, I would request it no later than the end of February. Because let's face it, if you do it on March 1st, they have 15 days to send you the plan. We're at March 15th. You have 2 weeks. Let's say you send it back really good on March 16th. They now have, what is it, two months to conduct the evaluation and hold the IEP. March 16th, April, May, mid-May, you've got your evaluation done and you're holding an IEP. Okay. Anything much later than that, you're taking a chance on it getting held over past the summertime. And now you're holding your meeting, your IEP meeting in September or August, whenever your district resumes. So that's a big deal. Okay. That's why I would say at the latest, March 1st is the latest that you want to ask for an evaluation. Generally speaking, I think early February is the time to do it. Okay, generally speaking, just to be safe. If the school district refuses to evaluate, if they fail to meet the 15-day deadline, if they fail to respond, you can do a state compliance complaint. Okay, so anytime they, and this addresses some of the issues that were raised in chat earlier. If you ask for the assessment plan, they have 15 days to get it to you. If 20 days go by, 21 days go by, you could do a state compliance complaint at that point because they failed to do it. Okay. Now, if 30 days have gone by, then they still have failed to do it. You can do a state compliance complaint. If they do, now here's a trick that you can use. If the school district fails to respond and it's been like, more than 2 weeks, maybe say less than 2 months, I would say the answer is no. The school has refused to provide an evaluation. And so when you do the state compliance complaint and you include your proposed resolution in it, your proposed resolution should not be, well, because they didn't respond, they must immediately do the evaluation within 2 weeks of the conclusion of CDE's investigation. I would not do that. Instead, I would wait a month. I would send a letter at day 16 and say, hey, I haven't gotten the assessment plan. I hope you're okay. Hope everything's all right. Please let me know. If anything's letter's incorrect, please let me know in a reasonable period of time. And then what you do is I would wait and I'd stay silent. I wouldn't send a weekly nag letter. I wouldn't do any of that. Instead, I would then send a letter at about, I don't know, a month, maybe 2 months. And I would send a letter and say, at this time, I have not heard back from you concerning the evaluation that I requested on the date, blah, 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 and sent a follow-up letter 16 days later. Because I haven't heard from you, I unfortunately will need to use more formal tools to resolve this. If anything is letters incorrect, please let me know in a reasonable period of time. And then what I would do is I'd immediately file a state compliance complaint, and I'd say, I disagree with the evaluation that the school district failed to conduct. The school district failed to do an evaluation. They failed to meet the timelines. And as a result, I disagree with them. And I am requesting an independent educational evaluation. That's one way where the school's inactivity and your evidence, the letters of understanding you've been writing, come into play. Because now you can state, hey, look, they didn't even respond. I'm asking for an independent educational evaluation. I don't want to waste time now with the school doing their eval and then me possibly disagreeing with it and having to get an IEE. Nope. So it can be a very powerful tool. Okay. The legal requirements. Okay, so now we're getting to this handout, or excuse me, to this handout that you saw earlier. Okay, so we're going to cover these in the presentation themselves. Again, copies of this will be dropped in the chat. You will have copies of all this stuff. Okay, it'll also be emailed after the presentation, so it will be available. Okay, first of all, evaluation and evaluation materials and procedures have to be free of discrimination. Okay, so if there's anything in there that's discriminatory on the basis of race, culture, sex, gender, any of that stuff, no good. Okay, right away the evaluation doesn't meet the legal requirements. Now, one thing I want you to keep in mind when we talk about these requirements is sometimes parents say, oh, they didn't do that. Aha, now I can ask for an independent educational evaluation. Okay, you can, but remember, generally speaking, when it comes to this stuff, it's all about the straw that broke the camel's back. This is about showing that there are huge failures across multiple areas. Okay, it's very rare that there's an actual smoking gun. It's very rare that somebody's going to do something about one thing that's not proper here. So instead, you want to make sure that you've got a lot of evidence. Okay, so let's get back to the requirements. Evaluations materials have to be free from discrimination. They need to be presented in the school's native language unless clearly not feasible. Okay, so if the student's language is not English, make sure the language card that you have completed with the district, so usually you have to identify what language the student speaks. Make sure you put in the accurate language. For some students with autism, the language they use is PECS, right? Picture exchange communication. PECS may be your student's language. Put PECS on the language card. Okay, they will have to do the evaluation in terms of PECS. Now, if it's clearly not feasible, it's clearly not feasible, but they should be giving an earnest effort to try and make it happen. Okay. Include relevant functional, developmental, and academic information. The evals must include information about academics, developmental issues. So now remember, developmental issues includes things that the student should be able to complete by a certain age, right? Remember here, we have our developmental milestones. Oh, here we go, developmental milestones. This booklet will tell you what kinds of skills are advanced at a certain age or not. And it's broken up into many different areas: physical development, social, emotional, intellectual, language, the classroom environment, instructional strategies, all this different stuff. So this will let you know if a skill is too advanced for your kiddo. Now, if your kid is over the age of 5, this only applies to kids over the age of 5. If your kid, or excuse me, up to the age of 5, up to the age of 5. So because this only applies to children up to the age of 5, if your child is over the age of 5 and they can't do anything on the developmental milestones, they're behind. Clearly, they're behind. Okay, so it should include developmental things. And then functional. Functional is usually interpreted as life skills stuff. Okay, so life skills stuff would be eating, chewing, swallowing, because they do that at school. It's a school-based skill. They eat at school, recess, lunch, recess, snack time, that kind of stuff. Dressing, bathing, all that stuff happens at school, right? Well, maybe not bathing, but dressing does, right? Personal hygiene does after using the restroom. So all those things are school-based skills. They happen at school. So the evaluation should describe those issues, all of them: functional, developmental, and academic. Okay. It must be used to measure the things for which the evaluation is valid and reliable. Okay. The requirement is that the evaluation must measure the things for which it reliably can measure. Okay. I once saw a school district use a test that was given to kindergartners on a student in high school. Okay. And then when they were demonstrating that there were lots of deficits, They were making the case to move the kid out of a typical classroom into a special education classroom, which was not what the student wanted. It was not what the family wanted. It didn't meet the student's needs. They had a lot of social skills deficits and wanted to be in a typical classroom. So by using an evaluation that was typically given to students no older than the age of 6, or recommended by the testing manufacturer to not be given to students older than 6, they weren't using an evaluation that was valid for its purpose for high school students. Okay. Is it a current version of the evaluation? Remember what I said. The testing companies, the evaluators, the scientists that develop these things, they're constantly changing the questions to make sure that the results of the evaluation follow that bell curve shape. Okay, so did they use a current version of the evaluation? If a more current one is available, they're not following this requirement. Does it truly measure what it's supposed to? Okay, like the example I already gave. Are the results consistent over time? We would expect that. We expect the results to be consistent no matter what evaluator gives it for inter-rater reliability. Somehow I still remember that. Inter-rater reliability. Okay, that the results are more or less the same no matter who administers the test. Okay, that tells you if the test itself is valid and if the evaluator is. All instruments are not created equal. All evaluation tools are not equal. So the child's qualities should help inform the evaluator which evaluation they use, right? So if an evaluator, let's say they're going to test a student with autism, right? A lot of students with, it doesn't even have to be a student with autism. Let's say the student doesn't speak, okay, regardless of their age. Student doesn't talk. Does it make sense to use an evaluation that requires the student to give a verbal answer? Of course not. That's what we're talking about here. If they use an evaluation that requires a verbal answer for a student who isn't verbal, it makes no sense. They should be choosing an evaluation that allows the student to point, that isn't language dependent. Okay. Same thing, untimed tests for kids with ADHD. Kids with ADHD, hard time focusing. Why use a test that has a timed response? Doesn't make sense. So they got to choose the thing that's right for people. Now, it may occur to you right now that, I may need to learn a lot more about evaluations. And if it does occur to you, you're in a good place. You're thinking the right way. Okay. You're thinking the right way. I know one mom, 4 of 5 of her children had learning disabilities. And for those of you who may have experience with this, you know that finding out and discovering and accurately diagnosing a learning disability can be really tough, really tough. Well, guess what? This mom who has 4 out of 5 kids with learning disabilities became an expert on evaluations. They knew every evaluation that was out there to measure the issues that impacted her children. And she knew exactly which ones were appropriate and which ones weren't. And so how can you use this information? Remember, if there's enough requirements violated, if they're not following enough of these requirements, it gives you more to disagree with their evaluation and get an independent educational evaluation. And again, we'll talk about that IEE in more detail later. But the purpose of this is knowing the requirements so that you can have substantive reasons to disagree with their evaluations. It doesn't mean you'll disclose them right away. You don't need to talk about those things, but knowing that they didn't meet the legal requirements will make it easier for you to get an IEE, an independent educational evaluation. I'm going to talk about that a little later on. Okay, the evaluations must be given by trained and knowledgeable people. Okay, trained and knowledgeable people must do the evaluation. So they need to go through the training. It's just that simple. They need to have been trained on how to do it. And so ultimately, because they need to be trained in how to do it, if they lack that training, then ultimately they are not sufficiently trained. It's just that simple. It's self-evident. Okay, now looking at, you want to make sure they're experienced in evaluating students with disabilities. They got to have that experience. They just have to, because without it, how do they know how to do an evaluation properly? Okay. Now I'm going to stop screen sharing for just a moment because I want to show you something else. Okay. I'm going to go to, here we go. I'm going to go to, this is my browser. And right now, as you can see, I am on the Department of Consumer Affairs website, which is in the presentation. Okay, I'm on the Department of Consumer Affairs website, and it's in the presentation. Here's the thing. The Department of Consumer Affairs, one of the things you can do on their website, and I'm doing this from the very beginning, so you can see me look for it, you can figure out how to navigate it, is you can go to Consumer. And in this section, you can look for a license search. And now you can look for the license of anybody. So, and we have here these are the agencies that are not included. Here's the board and bureau that we're talking about. So let's say you want to check the licensure of a psychologist. Well, boom, you go to Board of Psychology and you enter, you can even leave all this, most of this stuff blank, and you can enter the name of the person. So I'm just going to make up a name. I'm just going to say, I don't know, Henderson. Okay. So I entered the name Henderson and I hit search. And I get, okay, I've gotten everything in the world. That's not good. Here, let's clear it. Let's go to psychologists again. And I'm going to choose Henderson as the name. And I do a search. And guess what? I am now looking at all the licensed psychologists in California with the name Henderson. Now, if you've got their license number, you can input it on this screen. And then you won't get everybody. You'll just get the one person. If you have the first name, all that kind of stuff, it'll just help you find it more quickly. But again, I cleared it out. Silly me. Here we go. And I'm just randomly choosing the name Henderson. So if we look here, we can see here, I'm going to randomly choose one person. Yes, we were looking for Rochelle Henderson. That's the person we wanted. What do we know about Rochelle? Her license expired in 2012 and her license was canceled. Do we want to know more about it? Sure. Well, now we've got her address, mailing address, presumably, but perhaps her residential. And that's it. She doesn't have a current license. She doesn't have a current license. Guess what? Shouldn't be doing evaluations. She's not licensed to do that job. So that information is in the, and I just saw somebody give a surprise face on the chat from the reactions. So yeah, that's one of the things you can do. One of the first things you can do is check the licensure to make sure that the person actually has an active license. Holy smokes. So, and again, if they don't have an active license, did they have someone who is trained and knowledgeable? Well, maybe they were trained, maybe they were knowledgeable, but they did not meet the requirements because their license isn't active. Okay, moving on. They got to follow the directions given by the testing manufacturer. The testing manufacturer gives instructions on how a test should be done. Well, bottom line is, they got to follow those directions. They got to follow them. So, tests for certain kinds of functioning have to be done by a credentialed school psychologist. You got to know what these directions are from some of the evaluators themselves. Okay, I'm going to talk about where you can get that information later. Okay, somebody asked, does it happen often that you check a license and they don't have their license current? For me, it depends. I mean, I had a period where it seemed like about a third of every single one I was checking was suspended or expired. And then for everyone I was, and that lasted for a period of like 2, 3 months. But then every single one I checked after that for like the next year or so, I only found like one or two that weren't licensed. So it's just random. It may be by school district. You may find that a school district may be better or worse than others because ultimately, it depends if they check on it. Like that's an HR function. I see that as something like the HR department would make sure everybody's valid and current in their licensure and that sort of thing. Maybe not, but it can and it does happen. Yeah. And I'd love to say, it happens more often with districts that have poor reputations than others. That's not true. I'd love to say it. It would give some logic. It would make it easier to understand. It doesn't seem to happen that way. Um, can the schools use an evaluation from last year due to the pandemic? Sure, their obligation is only once every 3 years. So sure, they sure can. But if you've requested an evaluation during a time period when it wasn't suspended, they needed to have gone through that evaluation process too. So, okay, let's move on. Got to assess specific areas of need. Got to address specific areas of need. Speech, psychology, gross motor, fine motor, academic, all these things. You guys have probably seen these things many, 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 many times. So, and again, if you haven't, look in the Special Ed Rights and Responsibilities Manual. They basically include many areas of need. So one of the things you can do when you request your evaluation, don't hide the ball. Be very specific. I'm requesting an evaluation on gross motor and fine motor and sensory integration issues for my child. Okay. Now, don't ask for a particular evaluation. Don't. I strongly recommend you don't ask, I like the Woodcock-Johnson. Please use the Woodcock-Johnson. Don't do that. You're not an expert. The experts, the evaluators select. Besides, I want you to ask for an evaluation. They choose the tool. Remember, if they choose a bad tool, great, more grounds for an independent educational evaluation. Okay. Some parents say, well, I want to make sure they do the right one from the get-go. Why? Why? Give them enough rope to hang themselves. It'll only help you down the line. Because, and if you fight with them now, they're going to say, well, are you a psychologist? Are you a speech therapist? Can you make that determination? You don't want to get in those kinds of arguments with folks. So don't. Okay. But they have to assess specific areas of need. Okay. See, there's a long comment in the chat. Okay, so yeah, I'm not going to be able to address that here. That's pretty pervasive and sounds like part of a larger ongoing issue. So we're going to move on to accurately measuring what is trying to be measured. It's got to be technically sound. Okay, now this one, I have a hard time trying to explain this one because it seems so self-evident to me. It's got to measure what it's trying. If we're measuring intelligence, it's got to measure intelligence. If we're trying to measure auditory skills, it's got to measure auditory skills. If we're measuring visual ability, it's got to do, et cetera, et cetera. It's just got to measure what it's supposed to measure. Okay, it's just that simple. No single measure. This is a biggie. This is all over the place in special education law. You got to use a variety of tools and strategies. You have to. Okay, so it can be multiple evaluations, it can be teacher observations, it can be other kinds of testing, it can be parent report. That's why they always get your input or should be getting your input before doing evaluations. Okay, so bottom line is they can't use a single measure. Okay, now I've just gotten 2 questions in the chat. I think everybody can see them, which is what's the best way to learn about all the different kinds of assessments out there? How do we know what to look for? How do we address this with the school? So here's the thing. One of the best books I've ever read on this is called 301 Special Education Evaluations. That's the name of it. 301 Special Education Evaluations. It's a great book. 301 Special Education Evaluations. And I'm looking it up on Google right now just to make sure. Yep, it's still here. The Special Educator's Comprehensive Guide. Okay, this is the real name. The Special Educator's Comprehensive Guide to 301 Diagnostic Tests. I love this book. And I'm going to put it in the chat right now. I just pulled it up on Amazon, and there you go. And this book has a variety of different tools. There might be even better tools out there than this book. So please, if you look around and you find something better, yeah, go with that. Go with that. This may not be the best book. It's been about 10, 15 years since I've looked for books like this. So, but 301, I love that 301 diagnostic test, because ultimately what it does is it shows you and very clear what are the current tests. They give you the website information of the testing manufacturers, so you can go on their website and learn more about it. I know people who've gone on eBay to get the testing manufacturer instructions so they can speak to that. They go on eBay and try and find psychologists that are going out of business or who have access. These examinations, a lot of them are very pricey, from a couple $100 to a couple $1,000. $800 is not outrageous. So these things are expensive. So it can be really hard to get the manuals, but get them. Why not? If it really matters for your student, now it may not matter for your kid. Evaluation is just maybe one part on the road. That's fine. But if you find yourself really puzzling over the evaluations, really looking at them, it may be it's crucial for you. Okay, least restrictive environment. The evaluation should talk about what is the least restrictive environment for the student. Remember, the least restrictive environment is more or less, the idea is that the student should be taught side by side with typical students with or without services. Okay, that's pretty much the least restrictive. Taught side by side with typical students with or without services. So what that means is, and until the level that they cannot be educated satisfactorily. Well, what's that? To me, what that says is you throw every service, including the kitchen sink, at that person, and if they can learn in the classroom, great. If they can't, then they're not in the least restrictive environment. They need a more restrictive placement. They need a placement where someone's in their face helping them more often. That's what this is about. It's about avoiding situations where we're throwing more services at kids than what they need. Okay, that doesn't help them. Okay, it doesn't necessarily help them. All right. Moving on. They got to evaluate all educational needs impacted by the suspected disability. All means all. Okay, all means all. They have to evaluate all suspected areas of impact of the disability, including these things. Okay, I'm not going to read them. Speech and language, self-help, et cetera, et cetera. So all these things have to be included in the evaluations. Okay, they have to evaluate all areas of suspected disability. Remember, and this might be something you want to write down, the special education mantra is there is a disability and that disability impacts the student in the classroom. So they have to identify all suspected areas of disability. They have to evaluate those areas in order to do a complete evaluation. Okay. They should use all data that's available. Can't cherry pick. You can't pick and choose. They need to use all forms of data that is available. Okay, or that are available, excuse me. Okay, so including information provided by the parents, and then they can use objective and subjective data. Now, how many times have you been told that the data you want to use is subjective? You can't use it. Maybe never. But I'm going to tell you, I'm going to show you a way how to create an objective measurement to something that's subjective. Okay, what's a subjective thing? How your kid did at school today. So when you ask the teacher, how did my kid do at school today? How did they do over the last year? Very subjective, right? But here's a way that you can make it objective. What you do is you get a sheet of paper, and maybe on the top half, you ask, how is my child's performance today? And then you do 1 to 5, right? And you have a smiley face over 5, you have a frowning face over 1, and you have a neutral face over number 3. And you work out with the teacher in advance that your child's performance can, that every day the teacher can circle what it is, or maybe do one in the morning, do one in the afternoon. And then the second question can be, what was my child's attitude today? What was their attitude? They have a good attitude, okay? Or it could be something else, okay? But, and then you do the same thing, 1 through 5, smiley face, frowny face, the whole 9 yards. You can do AM in the morning and PM in the afternoon. Do AM at the top, do PM at the bottom of the sheet of paper. Every day the teacher can fill this out. It won't take them any time at all to do, hardly, and they can send it home with your student under typical times. I understand many people are in distance learning, but they could email something like this to you too. Really, really low effort with really good data. Now, here's the thing. You can take that data and play with it. They're numbers, or you can turn them into numbers. So now you can get averages. Now you can put that stuff in a spreadsheet like Excel and play around with it. What does it say about your child's attitude in the mornings versus the afternoons? What do the data say about your child's attitude on Friday as compared to Monday? Right? I don't know about you guys. A lot of people seem to have bad attitudes on Fridays. They're dying for that weekend, right? So maybe you'll see a pattern like that emerge, right? Maybe you'll see that in the morning, the behavior is always worse compared to later in the day. Well, what's going on in the morning? Your child having a hard time waking up? Is there a psychiatric condition? Is there a bully that they encounter in that morning class? Is there a teacher? Lots of questions you can ask to get to those answers. But that's one way you can take this data and really play around with it, really get some meaningful stuff out of it. Present levels of academic achievement. They need to include that in their evaluations. They have to talk about what is your child accomplishing? How are they doing? Okay, usually, not always, but usually this is reported with grade level equivalents. Okay, grade level, you'll say like, okay, your kid is like is comparable to 2-1 grade, meaning the first month of the second grade. Okay, now the thing is this, when you're looking at those kinds of performance issues, you want to see the gap close over time. Okay, so in other words, if your child is in the 4th grade, let's say, and their performance is in the 2nd grade, okay, then what you want to see is from 4th grade to 5th grade that your child learns at least 2 grade levels of information. Okay, why? Because let's say in the 4th grade they're performing at the 2nd grade level. We don't want to see in the 5th grade that your child is performing at the 3rd grade level. 1 year of progress over the course of 1 year is no good when a gap of more than 1 year exists. The school should be trying to close that gap. So keep that in mind when you're looking at the present levels of academic achievement. Okay. One of the things the requirements include is that they need to explicitly state whether or not a student needs special education. They might just say, hey, look, a student needs special ed or doesn't need special ed, but they've got to comment on that in the evaluation, okay? Additionally, they need to note if additions or modifications are needed to meet the goals in the IEP or to be in a general ed class. So the reason for it to be in a general ed class is that least restrictive environment requirement, okay? If additions or modifications are needed to meet the goals of the IEP, believe it or not, an evaluation should say something like, hey, the student isn't quite meeting their goals and they should be getting additional services. Okay, and what additions and modifications are needed? A lot of times they'll say, well, the team should decide whether or not an addition or modification is needed to meet goals. Did they do this? No. They ditched it. They danced. They walked away from it. Okay, so again, they need to state whether or not those kinds of things are needed to meet the goals. All of your questions should be answered. We covered this a lot last week, using questions as a strategy to advocacy. Okay, the meeting isn't over if you still have questions. Ask those questions. Now, don't ask those questions to create problems. Please don't ask those questions just to take up people's time. You don't want to do that. Okay, but if you have a question, ask it. Ask it. Don't sit there in ignorance. Too many people tell me they've sat in meetings and not asked questions because they were afraid of looking stupid. To which I say, well, okay, but then if you allow the meeting to move forward and you didn't understand everything that was going on, was that a smart move too? Generally, it's not. So my recommendation, ask all the questions you got. Ask them. Don't ask them like a lawyer. Don't ask them rapid fire. Don't put people on the defense. Ask them like you don't know, because that's why you're asking, because you literally don't know. Okay. All right. Ideally, you should meet with the evaluator. At some point, you should meet with them. They should participate in the IEP. You should be told what the evaluation is going to include. Okay, what they're going to measure. Okay, so meeting with the evaluator can be really, really, really helpful. Okay. Some questions that you may want to ask. Who administered the evaluation? Do they have the training? How much training have they been provided? Do they have the licensure? Okay, hopefully you'll check the license before the meeting. Does the testing manufacturer allow this test to be administered in other languages? Many testing manufacturers don't allow it to be done in other languages. If you want to do it in Spanish, you got to buy their other evaluation in Spanish because maybe the language matters. So these are all questions that you can ask. And the reason why you're asking these questions at the meeting is to create evidence. Remember, part of your strategy is to ask questions, get answers, and audio record your meetings. In the age of Zoom, fine, record your meetings. Okay, let everybody know. Make sure you tell people you got to give at least, what, 72 hours notice? So give 2 weeks notice, give a week's notice. Don't hide the ball. Tell them you're going to record the meeting. Don't be waiting at the last minute to inform them, because if you tell them too late, you're not going to be able to record the meeting. Okay. When they say the test was informally administered, find out what that meant. And again, remember, you're asking these questions because you want to demonstrate they didn't meet one of the requirements or more than one of the requirements. Hopefully, you'll demonstrate that they didn't meet a lot of these requirements. Okay. Sometimes the evaluation is administered by the teacher. For some things, like I believe the Woodcock-Johnson, I believe, I'm not sure, but I believe that the teacher can administrate the Woodcock-Johnson. For some tests, teachers can do them. Some tests, the teacher is actually the preferred person to be the evaluator, okay? But in other cases, teachers shouldn't be doing it. So you can ask, who administered the evaluation? How much training did they have? Are they permitted to do so? Okay, and here's the value of those answers. If they answer those incorrectly, then it shows they didn't know what they were doing. More grounds for an independent educational evaluation. Okay, it says compared to his peers. Who are the peers? Students in a special ed classroom? Students in a typical classroom? Who are the peers? This is my favorite. Why do I see contradicting information in the evaluation? Here you said they don't need it, and there you said that they did. Which one is it? I don't get it. I need your help. Okay. So clarify when there's contradictory information and ask lots of questions about that, because you don't want them, if you're silent on it, and let's say you're in due process a year from now, you don't want them to be able to say, oh, well, I just didn't understand that. That was just a mistake. If you ask lots of questions and they give answers, it's going to be harder for them to say there was a miscommunication or they didn't understand. It's going to be more difficult. Okay. Did you observe my child? And then ask every detail about what they observed. How long did you observe my child for? There, that's not written down. You may want to write that down. How long did you observe my child? Under what circumstances? What were they doing? Were they on the classroom? Were they on the playground? What were they doing? And then if they don't talk about LRE, you can ask, how did the test results relate to LRE? What you'll find, a lot of people tell us that what they found is that the evaluator will dance if they don't know the answer. They'll just start talking and they don't give a meaningful answer. So all you got to do is just say, I'm sorry, I didn't understand. How did that relate to the LRE? I don't get it. That's all. Just stick to your guns about not understanding, and they need to explain it. Okay. And again, you don't want to act like a lawyer and make people defensive. You want to act like someone who's ignorant and just wants to learn what the truth is, what the facts are, so you're not ignorant anymore. Okay. Requesting evaluations, you can identify areas and sub areas that you'd like evaluated. We talked about that a little earlier. The evaluator chooses the test. So don't get into a fight with them about that. Don't let them make the mistake, and then you can ask for an independent educational evaluation. Okay, if they choose the wrong evaluation, that just helps you. Okay, now I've mentioned IEEs a few times. So what's the deal? First of all, you have the right to a second opinion, but you have to disagree with the school's evaluation. Okay. Now, typically, parents tell us that the reasons why they disagree with the school's evaluation is because it just didn't describe someone who sounded like their kid, or it wasn't internally consistent. Those are the two most common reasons. It wasn't internally consistent. Like, here you describe lots of deficits that my child has, but then in the recommendations, you recommend no services. How does that work? My child has no deficits but doesn't require services? Can you explain that to me? I don't understand. That doesn't make sense to me. Okay. Or the evaluation doesn't describe their child. The evaluation, it sounds like you're describing someone completely different. And you can disagree on that basis. My recommendation is to disagree on one of those two bases. Why? Because if you disagree on the basis of, well, you didn't meet this one requirement, well, you didn't do this, you didn't do that, what happens is, typically what we've found out is that districts will create draft evaluations, and then they'll change it based on your disagreements. But the overall conclusion will remain the same. And so what happens is they remove the things that you can disagree with by changing the draft evaluation, and now you're kind of stuck. Now you're kind of stuck. So instead, I would say you disagree with it because it doesn't sound like your child, or because it's not internally consistent. You describe a lot of things here, and then there's no conclusion that makes sense to me. Okay. Now, when you ask for an independent educational evaluation, they have to give you an assessment plan. Please cross out 15 days, and please write in reasonable amount of time. Okay, reasonable amount of time. CDE, the agency that does the investigations for state compliance complaints, allegations that the school district has violated the law, the standards that CDE uses have changed over time. In some time periods over the last 20 years, they have said, well, the law says 15 days. The law says without undue delay is the law. So the legal standard for regular evaluations is 15 days. We don't see why it should be any different than that. CDE has also said over the last 20 years that 2 months is fine. 2 months for the school to respond to your request for an IEE is just fine. And, we've heard everything in between. It seems like right now what we're hearing is CDE is moving back towards 15 days. Okay. So, if you don't get an IEE within 15 days, or response to your request for an IEE in 15 days, my recommendation would be, wait a little longer before doing a state compliance complaint, because again, CDE, if they're using different standards, it's hard to predict. So I would wait maybe a month. Okay. And that's just a suggestion. By no means do you have to do that. If you feel like, this guy who's doing the presentation doesn't get it, he doesn't understand how important these evaluations are, I shouldn't wait a day longer than I need to, that's cool. You got to do what's right for you. Okay. I don't expect everybody to agree with me on everything. Okay. So the school district must give you and pay for an IEE when you request it. Okay. Their only other choice is to take you to due process to defend their evaluation, to say our evaluation met all the legal requirements. Okay, well, great. So that's it. When you ask for an IEE, they either give it to you and pay for it, or they got to take you to due process. Anything else is not legal. They're not following the law if anything else happens. Okay. Now, sometimes families tell me, well, they wanted to talk to me and they wanted to sort of feel me out and see if maybe we wanted to do another evaluation that the school conducted, et cetera, et cetera. Okay, talk, wheel and deal. That's fine. There's nothing wrong with that. Okay. Some people say, well, because they wanted to wheel and deal with me, they weren't taking me to due process and they weren't paying for an IEE. It's okay to talk to people. It's okay. Okay. Have no fear to talk. Um, Now, the other thing too is when you disagree, and I apologize for not covering this on the last slide. When you disagree, it should be for an evaluation that should have taken place in the last 10 months to a year at the most. At the most. Okay. And the reason why is because most kids are different year by year. Most kids change a lot over just 1 year. And so if you're going to disagree with an evaluation the school did, my strong recommendation is only disagree with those evaluations that have been done in the last 10 months, maybe year at the most. Because let's face it, if a year has gone by and you say, I disagree with the evaluation that the school did, school's going to say, well, you have a right to have them done annually. So why don't we just do a new evaluation? And because a year has gone by, it makes sense. If you go to due process over that, you may lose that. Okay. I would guess it's likely that you would lose that. Okay. So no more than 10 months. Again, they only have these two options. That's it. When you choose an evaluator, make sure they're going to attend the IEP. Make sure they include recommendations in different parts. Because remember, if the services and the placement are at the top of the pyramid, that foundation is what was found in the evaluations, the plops, the goals, the accommodations and modifications. So as they build that pyramid to get to the top, you want to make sure that those recommendations are included at the lower levels so that you have the foundation to get to the result that you're looking for. And if you don't, well, then you're going to find yourself in trouble. But if you do, great. Even if you have to go to due process, because then that foundation will exist at the lower levels. And then the conclusion of the services at the top will have a disconnect. It won't make sense. Perfect. That's what you want to demonstrate in due process. That either the evaluation was conducted completely ridiculously, or that the evaluation more or less is okay, and it includes issues that should take place in the foundational parts of the IEP. And even though it included those issues, the conclusion at the top wasn't there. It just didn't make sense. It was floating on air. Perfect. That's what you want. Be aware of the mistakes independent evaluators can make. So read this article that's linked in here. And remember, if you have to pay for your own IEE, or if you pay for an evaluation and it is used in the IEP, the school's got to pay for it, because you have a right to a free appropriate public education. Is it free if you paid for an evaluation that was used to develop your child's IEP? No. If you paid for it, it's not a free education. So if you paid for it, it was used, included in the IEP, you can ask for the school to reimburse it. Make sure you have your receipts, and make sure that you make the request only after the IEP process is done. Okay, you don't want to be arguing about this kind of stuff while you're providing or withholding consent on the IEP. And if they refuse to pay for it, you can do a state compliance complaint. Remember, state compliance complaints are allegations that the district isn't following the law. If they're not providing a free appropriate public education, they're not following the law. So it's a great way to get reimbursed for the evaluations that you may pay for. I would not recommend always paying for an evaluation yourself and bringing it to the meeting and calling it an IEE. I would generally recommend that you try and go through the IEE process that they have. But if you got a lot of money burning a hole in your pocket and you want to hire an evaluator, go for it. If there's a crucial issue or a crucial area and your child is really falling behind and it's just that important, then fine, pay for it and do it yourself. Okay. So can the districts just say they are not including IEEs as part of their evaluations? I'm not sure if I understand that question terribly well, but if you provide an evaluation or the school district paid for an IEE and they're not including it in their evaluation, I'd say good, fine. It doesn't matter, because ultimately an independent educational evaluation is exactly that. It's a different evaluation. All right. So for them to include it in their evaluation doesn't make sense to me. Okay. The question itself doesn't make a lot of sense to me. So can they just say they're not including the IEE? Yeah, sure. But here's the thing. Remember, they must consider all reports given by the family. They have to consider it. Now, what's consider? Can they just say, okay, we've got this IEE and we're not even going to look at it? They could say that, but then they're not following the law. So keep that in mind. Keep that in mind. Always put your requests and concerns in writing, write your letters of understanding, be able to prove that they received it, okay? Clearly voice your disagreements at the IEP. This does not mean fight with the IEP team at every turn, okay? Don't do that. But instead, when you make a request for a service, and if the team says no, my recommendation is that you ask them why. Take notes when they explain why. And then say to them, hey, look, I understand you said no for the following reasons. I want to make sure that you've considered all reasons for my request. And so you indicated that you said no because of blah, 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 blah. But did you also consider yada, yada, yada? And then did you also consider blah, 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 and blah, blah, blah? So once again, I'm going to make my request for the service of blah, 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 blah. How does the team decide? And then your job as a parent is to get a yes or a no. And if they say anything else and you're not sure if it's yes or no, say that. Say, I'm sorry, was that a yes or a no? Well, blah, 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 and the moon is in the seventh house and Jupiter's on Mars and that peace, love, and understanding. Okay, I'm sorry, was that a yes or a no? Okay. Those are lyrics from a song. I always use those as just filler language. So bottom line is did they give you a yes or a no? Now, that's after you took a shot at trying to convince them a second time after getting their reasons for no, you got to get a yes or no from them. If they say no, here's my recommendation that you say, okay, I understand the team has said no. Please indicate my disagreement in the IEP. Please write it in the IEP, and let's move on to the next topic. Thank you. Okay, why? Because you don't want to sit there and argue all day long with the team. It doesn't make for good vibes, number one. Number two, it doesn't mean you're going to get what you want to get. And number three, you're not completing the IEP process. You're not going through everything. So now what you're doing is you're creating delays that are going to require 3 meetings, 4 meetings, 10 meetings. And if you do that, no good. Okay. So it's really important that you take your one shot to convince them and change their minds. And if they don't, just say, respectfully, I disagree. Remember, even reasonable people can disagree. So respectfully, I disagree. Let's move on. Okay, going back to the question. So to get the school district to pay for it, it only has to be considered as part of the evaluation that's done by the parent and therefore pay for it. No, that's not exactly what happens. So let me go back and clearly explain this, because if you are asking that question, there are likely other people who are also asking that question. There we go. So here's the thing. If you pay for your own evaluation, and here's the key part, and it's used in the IEP, the school district must pay for it. Okay, so if you paid for your own evaluation, the school district considered it, and they said, we're going to reject it totally. We're going to ignore this. We're not even going to consider it. You've given us this eval, we're not even consider it. Great, they're not following the law. Game over, you win. Okay. Now, if they say, oh, you've paid for this evaluation, you've given it to us to consider. Okay, we're going to consider it. Okay, what do you guys think? Yeah, I don't think so. I don't think so. You think so? I don't think so. You. Okay. No? Okay, we considered it. We're rejecting it. Thank you. And they don't have to pay for it. But if you paid for it, if it's used in the IEP, then you should be reimbursed. Okay. Now that's why I make such a big stink earlier on the previous slide about making sure that your independent evaluator includes lots of stuff on goals, accommodations, modifications, because what many IEP teams will do, in our experience, is they will say, look, well, oh yeah, you know what? This independent educational evaluation is, wow, it's got great goals. We'll include some of that. We'll include some of the modifications and the accommodations. The services, no, I'm afraid we're going to have to disagree with those services. Nope. But then what happens is they used it in the goals, the accommodations, sometimes in the plops. That's great, because then they used it and you can get your money back. Okay. It also is great because, again, they're including information in the foundational parts of the IEP to hopefully get you to the services and outcome that you want. And if those foundational parts of the IEP are present, but the right conclusion is not, great grounds for due process. Great grounds. Okay. So I hope I answered that question clearly. Adequate versus optimal, read the article. Never sign the IEP after the IEP. Never, or I should say, never sign it immediately after the meeting. Okay? Never. Always take it home, always review it, and always sign it within a couple of days. The law says a few days. A parent must sign it within a few days. School districts in due process are using this as an argument to demonstrate that that the parent is difficult to deal with. The parent doesn't sign the IEP, or if they take 2 weeks, a month to sign it, they make the case to the judge that the family is unreasonable and can't be worked with. And they win because of that. They're winning. So as a result, always take it home, always sign it within a few days. My recommendation is, if the IEP is on Monday, Tuesday, or Wednesday, return it no later than Friday. If the IEP is on Thursday or Friday, return it no later than Monday. Okay. Now, when you sign it, you can sign it in complete agreement. You can sign it in complete disagreement. You can say, I withhold my consent from this IEP. I am requesting stay put. Please implement the last agreed upon IEP. Okay. So that's basically that. Remember, questions are collaborative. Arguing and yelling is not. And we've got a clarifying question here. Confused by my definition of used in the IEP. Do you recommend it is written in the IEP that is being used or considered or accepted as an IEE by the team? So here's what I mean by used in the IEP. If the evaluation or report that you have provided to the school has a particular goal, language for a goal, based on this student's deficits, I would strongly recommend that the IEP team consider the following goals and include them in the IEP. Goal number 1, goal number 2, goal number 5, etc. If they take that goal and they copy and paste it into the IEP, it has been what I am calling used. Okay, that's what I mean. It's been used. So when I say, did they use stuff from the report, like the goals, the accommodations, modifications, what I mean is, did they write it into the IEP? Did they copy and paste it into the IEP? If the answer is yes, it was used. It developed your IEP. Okay. Now, if it wasn't used, if it wasn't included in the IEP, then it was hopefully considered not used in the IEP. You're not going to be able to get your money. Why? It wasn't used to develop the IEP. Okay. And if you continue to have difficulties with that, if that understanding, if that explanation doesn't help you with your understanding, please feel free to reach out to us, and I'll be happy to great, got it. Thank you. Okay, excellent. Yay. All right. Yeah, sometimes my use of hyperbole makes it a little tough. And I'm sorry about that. We've got a number of resources here. And again, you've got this. We'll be putting this in the chat momentarily. And then we've got a number of articles that you can read. Strongly recommend, if you didn't hear my routine before, or if you can't access my prior trainings on this, read A Letter to a Stranger. It's really a great article about writing letters of understanding. And then lastly, please sign up for our newsletter. You can sign up for our newsletter by just sending an email to losangeles@scdd.ca.gov, and we will send you information. Right now, during the pandemic, as information is timely, we're doing more newsletters with less content. And the reason why is normally we do them about once a month. And unfortunately, we don't want information to get stale right now. And so, or fortunately, I guess, we don't want information to get stale. And so we are sending out newsletters more frequently, but they're smaller and shorter, just to give the information that people need. I expect that as the pandemic winds down, we will go back to our previous style of having newsletters that are about monthly, that are fairly chunky. We don't give your email address out to anybody, so that's basically it. We did schedule this training from 9 to 11:30. So what I'm going to ask is if folks can please fill out the poll. And so, Tamika, if you can please start the poll, it should appear on your screen. I just launched it. Yep. And it just appeared on my screen. So if all of you can please fill out this poll. The reason why we're asking you to do this is for a couple of reasons. Number one, our funding agency in the federal government wants us to report out the outcomes of these trainings. So this gives us a bit of insight into the outcome of the training. The other thing too is I'd like to know if I'm doing a decent job, and at least one of the questions targets that. So if you all can please fill out that poll and just click the buttons that as you see them to answer each one, and we'll share that for you in a moment. What I'm going to do is take a break from talking for a moment. Yes, it's true, I can do that. And what I will do is I'm going to drop into the chat all the files that were used as part of this presentation. Okay, so again, please, if all of you can fill that out. If you do have questions, please feel free to drop those questions into the chat. And let me drop those in, and I'll leave you be while you all fill out the evaluation. And I see more and more people are getting it done. We still have 22 people here. We only have 12 completed. So again, if you can fill it out, we deeply appreciate it. I can't force you to do it. So if you don't want to do it, I understand that too. That's quite all right. But again, like I said, I would appreciate it if you all fill it out. Okay. And you all should see a number of PDFs getting dropped into the chat. And these are all copies of the presentation and those other materials that I pointed out at the start. You can't forget to include the bell curve. So we have a separate document here just for the bell curve itself. And that's everything.
And Chris, just for the group, I will mail out all of the attachments as well as the presentation to everybody who attended the session. So if you can't download it for any reason, don't worry. I will be mailing it out probably later this afternoon so that you'll get everything.
Thank you very much, Tamika. And I'm just putting that in the chat right now as well. All the documents are here in the chat, but as Tamika said, the documents will also be emailed to you as well. We're not about hiding information. We're all about sharing information. So, and then we've got a few thank yous in the chat. Thank you. Thank you for attending. Really glad that you could make it. Makes us feel good about the effort we put into this training. My daughter is only 3 years old, so I am new to this. And I totally did not make the connection that you two are the equivalent of Sonia Bingaman in Sacramento. Yes, so being the state council, we have local offices throughout the state. And so as a result, some of you may know some of the managers in your area. Tamika and I are both the managers for our areas. I'm in Los Angeles. Tamika is in the San Bernardino office, which covers Okay, Tamika, I may need you to help me out, but San Bernardino, Riverside, Inyo,
Inyo and Mono.
Mono. Okay, that's what
Uh-huh.
I thought. So yeah, I always want to throw in Imperial too, but I know that's San Diego. So okay, cool. So between the two of us, we have a huge chunk of Southern California, and bottom line is that we're the managers, and we may be similar to those that you've worked with before, like Sonia Bingaman, David Grady, Scarlett, Mary Ellen. Oh God, am I really going to name all the managers now? Sarah and everybody else, Lisa, and the works. So we got a few thank yous and a few great trainings. Thank you very much. I'm going to end the poll right now because looks like we haven't had any additional comments to it yet. Oh wait, attendees are now viewing. 8:15 of 18 have voted. Okay, 3 people are still working on it. I'm not going to end the poll. Okay, what else? All the documents here in chat. Okay, thank you, great, thank you. Again, thank you all. Someone's indicating that a particular school district is getting worse and worse with retaliation in the Coachella Valley. And part of the reason why Tamika and I did put this training together was that while each of us as managers, we all have our areas of expertise. There's some things that I'm great at, and there are some things that I'm not great at. So, like, for example, Tamika is a whiz when it comes to emergency preparedness, working with law enforcement. That's not in my bag of tricks. But IEPs are. And we knew that some families, a number of families, are having difficulties within San Bernardino, Riverside, Inyo, Mono counties. And that's why we got together, since IEPs is part of my bag, or in my bag of tricks. Bottom line is Tamika asked me to come and do this presentation for you all so that you can benefit from this. And the great thing is, being Zoom, we can train everybody statewide, and no matter where you are, so long as we teach this with a statewide perspective, we should be good to go. So awesome that we're collaborating, working together, benefit families. Yeah, I agree, Kidada. And so, yeah, I think it's quite wonderful that we're able to do that. Because again, it's a way to make sure that we can all work off of each other's strengths. Okay, so I'm going to share the results of the poll right now, so you all can see. So we have a number of people who've attended today who are family members and some professionals. As a result of this, it seems that everybody feels that they will be able to have more advocacy skills and abilities, which makes me ridiculously happy. I'm better able to say what I want from everybody. Everybody except one person is participating in advocacy activities, which is great. And so my hope is that one person who is not participating right now can do so better in the future. Wow, about half of our respondents are on boards, committees, or some kind of advocacy group, or serving in some kind of leadership position. That's wonderful. Everybody's been happy today. Awesome. My day's made. This is a few people. This is your first time here, and we've got a great deal of diversity here in our attendees. Almost entirely people who identify as females, and a lot of people work in this field as well, which I think reflects some of the professionals that are here as well. So I'm really, really, really pleased that all of you are here and that you've been able to attend. So again, with those emails that you'll get with all the files, what we will do is send the files to you. And if you do have questions, you'll have an opportunity to be able to provide those through those emails. I want to thank everybody once again. And oh, great. Tamika put up some information. Yeah, please go ahead, Tamika. Why don't you talk about that?
I just wanted to announce to the group that we are taking input in regards to the vaccine, and our executive director, that's our big boss, is actually a member of the Community Vaccine Advisory Committee that is working with the governor's office. So if you are interested, the first session was this morning, it already passed, but there are 2 sessions tomorrow. I will also email that whole schedule out, not just the morning meeting, for tomorrow. With these materials, and please provide your input. We need honest information. How you truly feel about the vaccine is going to be so imperative to the community. So with that, if you guys could just share and get the word out, and also participate yourself. And if you can't participate, you can email those comments, and I'll send all that information out along with our flyer for the January training for compliance complaints and all these materials too. So just wanted to kind of throw that in there. It's not related to this training, but very, very, very important that we get that input.
Absolutely. Thank you for bringing that up, Tamika. So again, thank you, everybody. I think at this time, we'll end the call. And please keep in mind that flyer that's coming up on how to write special ed state compliance complaints, that's coming up on January the 13th. So thanks again. Happy holidays. Everyone take care. Take good care of each other. And we'll catch you soon. Thank you.